Okay, so hello everyone. This is Kim Hurston with the National Council of Juvenile Family Court Judges. We're hearing some background noise, so if folks could mute their phones, that would be great. So welcome to our webinar today. Our webinar is Immigrant Survivors of Domestic and Sexual Violence in Your Courtroom, Introduction to the Immigration System and Status Options. Our presenters today are Honorable Ramona Gonzalez from Circuit Court in Wisconsin and Gail Pendleton, who is an attorney, co-founder of ASISTA and executive director there. We want to thank OVW for providing us the support to conduct this webinar today. So we'll move on to our learning objectives and what we hope to achieve in today's webinar. So at the end of this presentation, participants will be better able to identify and understand basic avenues to immigration status for survivors of domestic and sexual violence, and identify what happens in court proceedings that may help or harm a survivor's ability to gain safety through secure immigration status. So I'm going to turn it over to Gail Pendleton, who will start our presentation for us.
Hi everybody, we're so glad you could join us today. Just to give you an overview of how we're going to approach this, the immigration system is extremely complicated and complex, so I'm going to try to give you some general concepts. We're going to run through some specific examples of how the system might work with different kinds of people, and then we'll come back to address some of the specific concepts later on and get your questions. So these are, again, vast generalizations of the kinds of routes to status that are in our immigration system, the big ones. We've got family-based immigration, we've got employment-based immigration, we've got a whole series of different kinds of routes to status that are essentially based on humanitarian interests, and then there's some miscellaneous routes to status that Congress has added over time, or that might be temporary statuses that the executive has ordered in different periods of our history. So we're going to use some real examples derived from Jennifer and Judge Gonzalez's experience. These are simplified versions to make it easy for you to follow, but we thought it would be easier to understand the typical immigrant experience and the various ways that they might be in the immigration system and trying to get status. So Raphael is Jennifer's spouse now, right, Jennifer?
Yes.
Okay, so you can jump in if I'm getting any of this wrong, but he moved originally to the U.S. to study from Eastern Europe, which means that he came in on a student visa and was attending college, and he was recruited out of college to work for a firm which sponsored what's called an H-1 visa for him. So think about who was controlling that process. At some point, he married Jennifer, and she filed a family-based application for Raphael. Because Jennifer was a citizen when she filed, he was able to get his status within 2 years of the marriage, and so he got what's called conditional residence. We'll come back and discuss what that means later. In order to, quote, unquote, remove the conditions from his residence, both Jennifer and Raphael had to sign a joint petition together and give that to CAS. And eventually, Raphael got his lawful permanent residence free and clear, which is what we call a green card. Let's do Judge Gonzalez's example, and then we'll come back and see if any of you or the other folks on the call can tease out what could be going on with the immigration system here. So this is Judge Gonzalez's father, a simplified version of her father. In their home country, the secret police threatened his life. They burned down his home and office, so he fled to the United States the next day using his brother's passport to get into the United States. He had to leave his wife and 5 children behind because of the danger and the need to flee quickly. He eventually brought in his family members legally, and later on, the children, including Judge Gonzalez, was able to apply for citizenship. So let's go back and discuss what routes to status do we think they were following, given those 4 big categories we had. So if any of you want to just throw your ideas out in the chat, I am meanwhile going to ask Jennifer and Judge Gonzalez what they think Raphael is pursuing. Was it employment-based? Was it family-based? Was it something else?
So what do you think, Jennifer?
So, so Raphael's intent coming over to begin with was coming in for education purposes and then ultimately employment-based.
Right. And then at some point you filed for him, and that got him into the family-based system.
Right, so he was able to kind of run through different types as he came to the system. So, he went from the employment to the family-based system.
Right. As we'll come back to this, the first two are technically what we call non-immigrant visas, meaning that they aren't necessarily planning on staying in the U.S. Once Raphael entered the family-based system, he was seeking an immigrant visa, and we will reinforce that again later. Can you tell us anything about the joint petition process? Do you remember that at all?
Well, I knew that we both had to sign. We both had to meet the time frame which was required, or else it would be problematic to maintain the family-based status that he continue on to his lawful permanent residence.
Right. And you had to be involved in that process, so that should be setting up bills in people's heads who deal with domestic violence. So now let's do Ramon. So Judge Gonzalez, I know these are a very simplified version of what the facts are, but very simplified version.
Yeah, very simplified version, but basically I believe he would have come into the country legally then because he did actually use his own passport to come into the country. He used his brother's passport to leave because he had to hide his identity on the way out so he wouldn't be arrested. So I think he probably...
Okay, wait, hold on a second. When you say leave the home country, he used his brother's passport so he wouldn't be arrested. Is that right? Okay.
Correct. So leaving...
Uh-oh. Hello?
It looks like Judge Gonzalez was disconnected, so we'll go ahead and try and get her reconnected.
Okay, and meanwhile, I'll run through the various things that could be going on here. So we kind of positioned his facts to illustrate a humanitarian form of relief. He likely would have requested asylum because he was fleeing persecution in his home country. He apparently didn't do it at the border because he was using his brother's passport and was afraid that his own security police would find him if he tried to enter the U.S. lawfully with his own passport. If he had asked at the border with Customs and Border Protection, they would have done what's called a credible fear interview, and that's to screen for people who have legitimate asylum applications. Assuming that didn't happen, he might have just came in on his brother's visa and then later filed for asylum with an asylum office. And then he would have it sounds like he was granted asylum. He eventually got his own lawful permanent residence. And at that point, he became a sponsor in the family-based system for his wife and children who were back in the home country. And that is probably how he was able to bring them in. Some asylum seekers can sponsor their family, but it's unlikely to happen if they're in the home country because they're still in a very dangerous situation. And we'll come back to when people can apply for citizenship later on, what we call naturalization. So just a little something on the grounds for asylum. There are 5 grounds, and this is an international accord that was signed after World War II when all those refugees kept getting turned away from different countries. So many countries signed this international agreement where they're all applying essentially the same law and the same grounds, which are race, religion, nationality, political opinion, and social group. So I would surmise that the likely ground here would have been political opinion. If you disagree with the government and the government it tries to kill you or burns down your house and your office because you disagree with them, that is usually a good sign that you are persecuted for your political opinion. A note, which we'll come back to later, is that one notably absent ground is gender. And I think that's probably because at the time gender wasn't considered a basis for persecution. So what's happening now when you see all the news about domestic violence and women being persecuted, most of the way those are being framed is in the social group category for asylum. Women who are abused in their home country and the home country won't protect them, for instance, would be an example of a social group. Another note is that if he had successfully applied from abroad, he would have, and gotten approved, he would have come in as a refugee. So that's the difference between asylum seekers and refugees. Refugees, it's the same standard for getting status. It's just that refugees have been approved abroad. Often they're actually in a refugee camp. And they come in with status, and they actually are eligible to get a series of benefits to help them settle. Asylum seekers often have come in with no status because they're fleeing persecution, and they're applying from inside the United States. And even when they're granted, they do not get the same series of benefits as refugees, but they are able to get lawful permanent residence, technically after a year, although there's such a backlog right now that it's usually taking longer. So it sounds like he probably then filed family-based applications for Judge Gonzalez and the family, and we'll come back to how that system works later on. Let's do some pre-test surveys next. Ask you some questions, and since Judge Gonzalez doesn't seem to have joined us again, Jennifer, I may ask you to help me with this, if you don't mind. So this is for those of you who are judges considering coming to the CJS on immigration and trafficking. This is actually an exercise we give you before we come. We find it very helpful for you to think back on when your ancestors came to the United States, what kind of barriers did they experience? And then compare that perhaps to the barriers you think that the immigrants you're encountering in your courtrooms may experience. So if anyone wants to throw some ideas out in the chat box, and maybe Jen, you can tell us what you think might have been true for your ancestors.
Judge Gonzalez is back on.
Oh, great. There she is. Yay. Okay, so Judge Gonzalez, do you want to give your thoughts on what kind of barriers?
Since we've just talked about Ramon, I guess part of the barriers is language. You know, my dad was very much about us not speaking Spanish at home because he wanted us to not be seen as lazy Mexicans, as he said, because of the stereotypes that were going on back in the 60s when we came. So there's always an issue with how much to assimilate and how much to leave behind.
And did he speak English or only Spanish?
No, he spoke when we came to the United States. Everyone only spoke Spanish. But by the time we were after our first year here, he prohibited Spanish from being spoken at home.
And that's actually very typical if you look at the kind of academic studies on immigrant acclimation. It's been true throughout history that often the first generation is the least likely to learn English because they tend to be out working hard to support their kids, but in order to get their kids assimilated, they're suggesting that they only learn English. And then often by the third generation, there's an effort to reclaim some of the language and culture that may have been lost in that second generation.
Right, because now what happens now is my children are complaining at me as to why we did not raise them in a Spanish-speaking household.
You can't win.
You can't win. You can't win.
So, and then, I mean, your experience is fairly recent. I wonder if any of the other people on the call can think back to when their ancestors came and think of any other barriers they may have experienced. Like, if they had suffered domestic violence, would they have thought to go to the police? And if not, why not? You know. And maybe while people are thinking about that, you could share your thoughts on that, Judge Gonzalez.
Well, I think you and I have taught at the continuing education series on this, and a lot of judges share that they would come, their ancestors may have come from Germany or Eastern Europe, and when they came, they were very closed and did not trust the authorities at all. And so there was there's several generations before they were able to really accept that the police was there to help, as opposed to just taking them away.
And they may have come from countries, even now, they may be coming from countries where the police are not going to be helpful, especially on gender violence issues.
Yeah.
Or if they come from, I've heard in the past Russian immigrants saying they assume the only way to get justice in the system is to pay money. So
and that's
helpful.
very,
Yeah.
It's not unusual for us for me to hear a story from law enforcement here on Eastern European immigrants who try to give them money when they get stopped for either a traffic violation or something small.
Right. So it's helpful to realize that's because that's what the system they come from. That's what they're used to. What barriers do you think, other barriers do you think the immigrant survivors in your courtroom might be experiencing?
Well, we see that all the time. The issue of language access is huge. We use, language lines, but it's very difficult for all of the different languages to be covered inside the courtroom. And it's one thing to be able to, order a drink in a bar in a particular language, but to understand the constitutional rights that you have in courtrooms is not so easy. And I guess when I have prosecutors or law enforcement who try and sort of say, oh yeah, well so-and-so can speak Spanish, I'd say, well, would you, if you were sitting in a courtroom in another country, would you just want somebody who just sort of knew the language to help you? That usually brings it home.
What do you think that especially the women who come in your courtroom are aware of their rights in our system?
In my particular community, we have a very vigilant advocacy community that helps, but I would say that's an exception to the rule, because you actually have to have the advocates involved with the immigrant community in order for that to happen. But I would say most of them don't really completely understand what their rights are.
And who do you think is their primary source of information on how?
Oh, well, that's I've seen it undoubtedly be the American who brought them into the country, or the other person who's been here longer, that tells them what the laws are and says, you don't have any rights. So they reinforce that as a means of...
And I mean, what we've heard, and I imagine you have heard this when people finally tell you, is that they've often told them, if you go to court, they'll take your child away and give it to me. So in addition to feeling they have no rights for themselves, the fear is instilled in them that accessing our system means they'll lose their children.
Sometimes it's not just losing their children. Sometimes it's losing losing their sustenance. It's losing their home. It's losing their support. It's a lot more than just. It really, I think, is basically giving up your entire being if you go to law enforcement, because in this area that we have, there's like, well, information is power. And usually the abuser has all the information, therefore he has all the power, or she has all the power.
And Mark Sanchez contributes that in addition to the language barrier, there are cultural and legal barriers that may exist. There are often misunderstandings about the law, like we talked about, or they may have been told or have experienced in the homeland that divorce is granted only by consent. So one of the teaching points is that you can't assume that immigrants in your courtroom have any idea how our system works or what their rights are. And it sounds like in your community you have advocates who are getting them this information before they appear in court, but someone, maybe a victim advocate in your court, may need to be pulling them aside and explaining all of this to them so they even know what to ask for in your courtroom or what they can ask for.
And I think there's also a place for judicial leadership in there and getting into the communities and doing the education yourself, because hearing it from an advocate is one thing, but hearing it from the judge or the prosecutor or the law enforcement is very much more reinforcing.
Yes, definitely true, because they're a trusted source of information. Excellent. Okay, so here are some of the things that have come up when we've done this. Language and just accessibility, the information, disinformation we've talked about. The potential for deportation is high on people's minds in general. They're not necessarily sure that if they call the police or go to the courtroom, they won't end up getting deported. So that's another place where your systems can be helpful in that. As we discussed, their own experience in the home country and how the systems work in their country, or lack of systems, like many countries don't actually have shelter systems. So you talk about shelter, they won't know what you're talking about. Economic barriers you kind of talked about. To add to that, we'll get into the fact that a lot of people can't work legally, depending on what kind of route to status they're pursuing, or only in certain situations. So there's a lot of economic control that goes on in many of these cases. And Mark mentioned the cultural factors, and religion is kind of part of that cultural factors, which, just as a footnote, we have those in the United States too. It's hopefully something you've experienced dealing with survivors who are citizens who may come from a culture or religion that discourages them, say, from reporting domestic violence or getting divorced, or generally airing dirty laundry, right, for a particular community can be an issue. So here, there have been a bunch of surveys done in the past couple of years about how, through advocates and law enforcement, about what they're seeing with the immigrant survivors they're trying to help. This was a survey that we did with many partners that we work with on the national level. And what we discovered is that 3 of the 4 domestic violence advocates who work with immigrant survivors said that their clients are much less likely to be willing to go to court, or they're afraid of going to court or contacting the police. And the National Immigrant Women's Advocacy Project did another survey that focused largely on law enforcement and folks in your system, and found essentially the same thing, that they're seeing a decrease in reporting and the willingness to assist in prosecuting crimes, and that their conclusion from the law enforcement is that this is making it harder for them to hold perpetrators accountable. So we're going to get into in a few minutes what Congress has done to encourage access to our systems and being able to hold perpetrators accountable. Something you might want to think about is, as Judge Gonzalez was discussing, is there any judicial leadership you can take to encourage people to access justice safely? Okay, wait a minute. I think we're missing the earlier polls, Patricia. Here we go. Okay, so this is kind of a pretest, and you all get to participate now. Is being undocumented a crime? They can vote for more than one, right? But I think here you're going to have to choose. It's yes, no, maybe, or no vote. Okay. So far, everyone says no. All right. My answer would actually be maybe. And that's going to be, as I'll get into later, because it kind of depends how you ended up being undocumented. Let's try the next one. Can you apply to be a U.S. citizen if you're undocumented? Yes, no, or it depends? You all think that's the right answer now, don't you? Okay. Actually, you can't. One of the things that is required before you can apply to be a U.S. citizen is that you have some form of immigration status that leads to naturalization. And usually that's lawful permanent residence. You may have heard lately about members of the military who are immigrants, because they used to have an accelerated route to naturalization. It's still in the statute, but they're, and I think some of them are still pursuing it. But that's pretty much the only exception where you can jump the lawful permanent residence step. Next one, please. Can you just apply to work legally if you're undocumented? No. That's correct. You have to, again, kind of a fundamental rule here is you have to have an underlying status that allows you to apply to work. There are forms of status, and we'll get into some that are designed for survivors, that allow you to work that are short of lawful permanent residence. Next, is that the end of the polls, Patricia, or do we have one more?
No, that was the end. And then I think the next one is just a chat question.
Yeah. Okay, so now that we've established that you have to have a green card, lawful permanent residence, before you can naturalize, and that you have to have a status that allows you to work to be able to apply to work, does anyone want to share what kinds of status you need to be able to apply for lawful permanent residence? Can anyone who has any kind of status apply for lawful permanent residence? Like Jennifer, do you think that your husband, when he was a student, could have applied for lawful permanent residence as a student?
No, I do not believe he could.
You're right, he couldn't. So there's only some forms of status that are routes to lawful permanent residence. The family-based status that we talked about is a route to lawful permanent residence, and some of those employment-based visas may be routes to lawful permanent residence, but they aren't always. So this takes us to some of the general immigration concepts. immigrant versus non-immigrant visas. Those are the two kinds of ways people can lawfully enter the United States. As we discussed, Raphael came in as a student. That's a non-immigrant visa because when he applied for it, he had to show he had an intent to return to his home country. However, while he was here, he was recruited by an employer for an H visa. That was still a non-immigrant visa, but many H visas may lead eventually to a green card. So it's kind of a quasi. And you'll see the U visas like this too. It's technically a non-immigrant visa, but it may actually lead to lawful permanent residence later. And then when Jennifer filed for Raphael based on the marriage, that was an immigrant visa. And then back to Ramon, he came, as you said, Judge Gonzalez, he actually came in on his own visa. He probably, his own visa or his passport, he probably entered as a visitor. And let's assuming that's true, that's another form of non-immigrant visa, that you have to show, to get a visitor's visa, you have to show that you intend to return to the home country. Once he got his status, it allowed him to apply for you all. What he filed for you were immigrant visas because he wanted you all to be able to stay in the United States.
Exactly.
Okay, and then here's another set of rules that you'll run across when you start dealing with a lot of immigrants and lawyers who know enough to ask you about issues. This is probably what they're talking about. There are two sets of rules that either prevent entry to the United States or are used to deport people that shouldn't be here. The inadmissibility rules are the ones that either prevent entry or they triage entry, and they also apply even if you're in the United States when you want to get a green card. So both Raphael and Ramon at some point had to overcome these inadmissibility visas. Inadmissibility grounds. I don't know if either of you remember any of that. Were there any issues that you can remember on inadmissibility?
No, my father was a physician in back in the Dominican Republic, so I think, and he didn't have any, other than the political work that he didn't have anything that would be a hindrance.
Right. No crimes.
No.
Something like that.
No, and he was educated, so that was helpful.
Right. Jennifer, do you recall anything coming up when you filed for Raphael?
He didn't have any barriers because there wasn't any past criminal or anything like that that would come up and possibly be a problem. So.
Right. Yeah. So those are the big barriers are the crimes. If you've got what were called crimes of moral turpitude, those will prevent you. Well, they won't prevent you. There's some waivers for some of these crimes, but they're often very hard to get. And actually, if you come to the CJS, we cover this in the afternoon session. Plug for that. What we're seeing in the survivor area is they're now looking at smuggling because often women will bring their kids in with them, and that's a ground of inadmissibility. They can often overcome it with a waiver. And multiple immigration violations will raise eyebrows, and people may have to overcome them as well. Those are the big ones that you'll see. One that's been in the news a lot lately is public charge, but that doesn't really, there are exceptions in the law for all of the survivor categories that we're going to talk about for public charge. And that basically means it's like this old tort law concept or something where you're becoming a burden on the public dole. And so what they look at is your use of public benefits, and they plan on looking at even U.S. citizens' children's use of public benefits. But again, all of the domestic and sexual assault survivors who qualify for these status are exempt from that investigation. And then until you naturalize, you are subject to the deportation ground. So let's say Ramon or Raphael had gotten their green cards, but they now commit a crime. They could be deported for that crime if they haven't yet gotten their citizenship. Okay. So back to who is undocumented. The reason I said it depends is that people who have committed a crime are those who entered unlawfully, especially after having committed a crime. Technically, if you get caught at the border, that's a crime. So what you may be hearing about a lot is that a lot of people are being prosecuted now for illegal reentry at the border. So that would be an example of someone who has committed a crime and is undocumented. Undocumented have not committed a crime. For instance, when Removal is what we now call deportation. And Ramon, assuming he filed for asylum right away, he probably wasn't technically undocumented, but if for instance his asylum case got denied and he was pursuing something else and it hadn't been approved yet, then he was undocumented during that period. The other thing to note is that if Jennifer was a green card holder herself and filed for Raphael would probably have to wait 5 years or so before he could actually get a green card, just because of what we call the priority system for the family-based system. And during that whole period, he would not be legally eligible to work, and he would be technically undocumented, and they could try to remove him. And often while people are waiting for their decisions, as I noted, on any of these bases, they're technically undocumented. Okay. So, who can work lawfully? Jennifer, do you remember the conditions on Raphael's visa regarding work? Those are often the conditions they put on student visas.
Right, so student visa, he could work only on campus for I think the first year and only about 20 hours. So there was limitations of where he could work and how long he could work.
And if he violated those conditions, they could attempt to deport him.
Yeah.
As an H holder, obviously the whole point was to work, but he could only work for his sponsor. Once you get a work, visas are completely controlled by the employer. You may have heard about labor certifications, and H visas are the ones you're most likely to have heard about, plus all the unskilled worker visas, but there aren't as many of those, and farm worker visas. In all of those cases, it's the employer who completely controls the process, so that even once the employee gets the visa, they do not have the liberty to leave and go work for another country unless they change their visa. As a visitor, could Ramon have worked? No. In general, non-immigrants are not eligible to work. There are some exceptions, as we'll discuss with the U visa. If, assuming Ramon applied for asylum, he could work if they had made no decision or no response within 150 days of the application, and he could work once it was approved. And as I mentioned, while Raphael was waiting to become a lawful permanent resident, until that actual green card was approved, he technically couldn't work unless his sponsor was a U.S. citizen. There's a special rule that if the family sponsor is a citizen like Jennifer, you can get a special kind of work authorization. It's called for those who are immediately eligible to adjust. And that's because our system is so backlogged that it can take a while for even those who are immediately eligible to adjust to actually get their green card. So I assume he got a work authorization fairly quickly after you filed for him, Jennifer?
He did, yeah.
Okay. All right. And if any of you have questions, I mean, again, this is very basic, so if you have specific questions about specific things you've run across, throw them in the chat box, and we'll either get to them as they come up or we'll come to them at the end. Okay, so what do you need to, now we're coming back to some of the questions. What do you need to apply for lawful permanent residence? This is a review. Jennifer or Judge Gonzalez?
What do you need to apply for a lawful permanent? You have to have a non-immigrant or immigrant status.
Right. You have to have some underlying status.
Right.
Yeah.
So some kind of status.
Exactly. Okay, and then we've discussed what conditional residence is. It requires the sponsor and the person, the spouse they're sponsoring, sign a joint petition together to remove the conditions. One of the reasons I highlight this is that survivors of domestic violence often think that because there's a 2-year limit on their green card, it means they don't actually have lawful permanent residence, and that the only way to get it is to go back with their abuser. Neither of those things is true, and we'll come back to what Congress did to fix that problem. And as we discussed, what you need to naturalize is from the vast majority of people, you need to have had lawful permanent residence for some period of years. For Jennifer's husband, assuming he wanted to naturalize, it would be 3 years because she was a citizen. If Jennifer had been a green card holder for her husband, it would have been 5 years. And for your dad, Ramon, Judge Gonzalez, sorry, Judge Ramona, technically, once you've been granted asylum, you can apply for lawful permanent residence after a year. There's a big backlog, but it's there, and eventually it can happen. Mm-hmm. And then they can apply to naturalize. I think it's after 3 years or 5 years. Okay. So back to the roots, just to solidify this. A lot of the people you'll see in your courtroom who are suffering domestic violence may be in the family-based citizen. The basics is the sponsor has to be a U.S. citizen or a lawful permanent resident. Citizens can sponsor their spouse and children of any age, even if they're married, and they're called different things, just so you know. And and their parents, but lawful permanent residents can only sponsor their spouses and children under 21 who aren't married. They can also sponsor children who are over 21, but they still have to not be married, and they cannot sponsor their parents. Employment-based, as we discussed, the employer controls the process. And family members of, let's say that you had wanted to derive status from Raphael on his H visas. Let's say you came in with him from Eastern Europe. Your status would be as a derivative of his status, and it would depend entirely on maintaining the relationship with him. So if you left him, you would be subject to removal. And then the third category is the humanitarian basis. Asylum is the one we've talked about already, and the ones we're going to get into now are for crimes experienced in the United States that Congress created over the past 3 decades. Okay, I think we've already covered this. You have to be in an approved status that leads to lawful permanent residence. There are different wait periods, both for getting your lawful permanent residence and then once you've got it, for applying to naturalize. Right. That. So let's run through the various parts of the system and who your examples may have encountered. So it's now all called the Department of Homeland Security, and under that you have Citizenship and Immigration Services, which generally deals with administrative applications, which we all call benefits in the immigration world. Immigration and Customs Enforcement's job is to detain and remove those inside the United States who are here unlawfully or have committed crimes and are subject to removal or deportation grounds. And Customs and Border Protection are the ones who do the same thing but for people entering the United States. And one important thing to know is that within 100 miles of our border is considered CBP territory. So if you live in northern Minnesota, I assume, or in Arizona, you may see checkpoints that are CBP checkpoints that are well within the country. And it's essentially the same as going through the border. So for the examples, both Raphael and Ramon sound like they filed what we call administrative applications, which means it's all on the papers, and there may eventually be an interview with Citizenship and Immigration Services. There's a special asylum offices, and their family-based system goes through local CIS offices as well. Immigration and Customs Enforcement would be those who say they committed crimes, either in the midst of applying or after they've gotten their green card. They are the ones who are likely to find and detain and attempt to deport them. And CBP would be the place where, had Ramon been seeking asylum at the border, he would have done that credible fear interview with a Customs and Border Protection person. The other parts of the system is the judicial part of the system is the Executive Office for Immigration Review. And using these examples, if either Ramon or Raphael was picked up by ICE, they would have the right to an immigration hearing in front of a judge, especially if they have some sort of status. And if you lose, and you have to obviously present a case. So let's say Ramon presented asylum, and Jen presented he's got an I-130-based petition. Just hold off, let him get his family-based petition, and he can get his green card from you, Your Honor, immigration judge, because immigration judges can do the admissibility determinations for people who are seeking a green card through the family-based system.
Right.
If the immigration judge denied that, then they could appeal to the Board of Immigration Appeals, which is the highest court in this administrative system, and from there you can appeal some kinds of cases to the federal circuit courts of appeal. Now, the Department of State is what deals with people trying to get in from abroad. So let's say that Jen had met Raphael abroad and she wanted to sponsor him from abroad. That's what, if you've heard of fiancé visas, that's what that would have been. She would have filed a fiancé visa. It's very similar to what she probably did here for him on the family-based system, except the interview happens at a consulate abroad, and he proves the inadmissibility and all the other requirements at that consulate, and then he comes in on a fiancé visa. And then eventually they perfect his status through filing other documents within the United States. This is often an issue for, you'll see immigrants in your courtroom who may have family members abroad, and to bring them in legally, those family members are usually going to have to go through a consulate abroad, and that can be very difficult, especially if you're talking about unaccompanied children. Or in our case, some of the consulates may not be as well educated on the special routes to status for survivors of violence. And there's no review, unlike we've seen in the CIS and the immigration court system. There is no review of the decisions made by consulates. So it's very important that they do those accurately and fully, and given that, and it's very hard because they're often separated. So we discussed some of the challenges for survivors. The obvious big problem is that there's kind of a built-in, I don't think it was intentional, but there's a built-in power and control in most of our system, that someone has to sponsor somebody else, and the exception is the humanitarian route. And so if you are subject to someone else controlling your filing, that sets it up for domestic violence. And that's, in fact, what encouraged Congress to do the first work on this, was that those conditions on the green card. I was working, we had a membership organization that let us know that a lot of women, Asian women in particular, are being trapped in abusive marriages because of the joint petition requirement. And so that's why you'll see in 1990, Congress created a special waiver for that. And as we'll get into, especially for family-based, there's certain eligibility requirements that you have to prove, like that it's a good faith marriage and that you're residing together, that for those of you familiar with abusers know often the survivors aren't going to have those documents. So that's a challenge for evidence for many of these cases. So here's what Congress did. In 1990, they created the conditional residence. That's the second item on here, the conditional residence waiver, and this is where they created the phrase we use in the immigration system for domestic violence, battery or extreme cruelty. And we'll come back to what that means later on. Also at the same time, at the behest of California social workers, basically, they created special immigrant juvenile status. Have any of you dealt with special immigrant juvenile status? Judge Gonzalez, have you had anyone come into your courtroom and ask for, or have you heard of them coming in and ask for findings that would be helpful to get special immigrant juvenile status?
And it's very unusual, and people aren't comfortable with it, but they do. Oftentimes it's in the guardianship arena, where they're...
Yeah, and we'll come back to the requirements. The reason they needed this was because these were kids who really shouldn't be reunited with either parent. Either they were abroad or they were neglectful or abusive, and we'll come back to that. And that's why they're basically, as you said, in the guardianship of the court or someone that the court is monitoring. Then after 1990, we were able to come back to Congress in 1994 with the evidence that the conditional residence waiver for domestic violence was really working. But the problem was that only worked if you already had gotten your green card. So let's say Jennifer was abusive and she had filed for Raphael, and she was a green card holder, so he wasn't going to get his green card fast. During that period, since she controlled the whole system, if he left her, he would lose his ability to get status. So what Congress created in 1994 is what we call the VAWA self-petitioning. And it's essentially the same as the family-based system, except if you show you were subjected to battery, extreme cruelty, and a few other eligibility requirements we'll get into later, then you could file on your own. And the idea was but for the abusive control of the system, this person should have had status by now anyway. And then in 2000, we were able to go back to Congress and show that that had, I mean, literally tens of thousands of women and kids had been able to flee abuse because of VAWA self-petitioning, but that only worked if the abuser was a citizen or lawful permanent resident. And I'm sure you've seen survivors who've been abused by people who they might have been married to, but they weren't documented, or for some other reason wouldn't fit the family system. So we worked with Orrin Hatch, who suggested doing a U visa, which, as you'll see, covers a wide variety of crimes. But even now, part of the agency, which is called the Vermont Service Center, which does all these cases, tells us that like 80% of U visas are domestic violence and another 10% is sexual assault. So this is still primarily a form of relief for survivors of domestic and sexual violence. And we basically tweaked it in the following years. We added on self-petitioning for parents of abusive U.S. citizens. I can't say, I've seen maybe 2 cases of that. And we added work authorization for those H derivatives that we talked about. If Jennifer had derived her status from Raphael, we added work authorization, so at least they could get free of them. And again, there haven't been a lot of those, but I think we're starting to see that again. And domestic violence as a basis for gender asylum has actually been at issue for at least 20 years. I think I've been working on it for 30 years, actually. So that's an ongoing issue that is not actually a congressional issue, because it is international law that we have signed on to. So let's get into the special immigrant juvenile status. So if you can remember, Judge Gonzalez, these are the things that you would need to do to help someone who's going to file for special immigrant juvenile status. So it seems like the issues here are the question of whether you have jurisdiction, whether you feel comfortable finding that reunification is not viable, and making findings of abuse, neglect, etc., and the best interests issue. Yeah, what are your thoughts on that?
Yeah, well, these are decisions judges make every day, and I think the important thing for us to remember is that that's how it has to be presented, because these findings are based upon what your state law is, and so these are decisions that juvenile judges are very comfortable making every day.
Great. So those of you who aren't the judges on this, I think that's the way to present it to the judges. And I have found that in general, a good way to present novel ideas to people is to analogize it to what they already do. So you already make these decisions in other kinds of cases, it sounds like. So it's just adding on the fact that it's in the immigration context.
It's really important for them not to be scared off by, well, what do you mean I'm going to find that there's danger in Honduras? I said, well, you would find out whether there's danger in Louisiana, and then you would make your findings here in La Crosse. So it's not anything different. It's just you're just applying your state law.
Right. Great. And if any of the judges on this have never heard of this, it's probably because the family law attorneys and the immigration attorneys in your area may not be aware of it. So again, this may be a judicial leadership thing, because I would bet you anything you are seeing children in your courtrooms who would benefit from this. And then I discussed this a little bit, but just to reiterate, since it's a hot topic, is for asylum you have to show a well-founded fear, which can be a variety of different kinds of harm, of persecution. And many years ago in Beijing, the world recognized that violence against women is a form of persecution, but it has to be more specific of that, as we discussed, because it has to fit a particular social group for gender-based asylum, since gender is not an official basis. And this is where the rubber is hitting the road right now, is you have to show that, especially when it's domestic violence or some sort of violence that could be positioned as, oh, this is just between a family kind of thing, or individual actors, you have to show it's violence that the government can't or is unwilling to control, that private actor. And then another piece is you have to show you can't safely relocate in another part of the country from which you're fleeing. So, VAWA self-petitioning. This is this thing we got done in 1994. And the reason we're covering the following things in particular is that we think that there are ways that you can be helpful or unwittingly harmful in some of this with people who may be appearing in your courtroom. So the basics of VAWA self-petitioning are that you have been battered or subjected to extreme cruelty to yourself or your child by a U.S. citizen or lawful permanent resident. If it's a spouse, you have to have been married within the past 2 years. We added a 2-year legal termination because we were finding abusers were running to the courtroom to get divorced to render their survivors ineligible. You have to show what's called good moral character, which is a term of art in immigration law. And you have to show you married in good faith. Again, a term of art in immigration law. It's called bona fide marriage. And so you know, under immigration law, marriage fraud means that you married solely for the purpose of getting an immigration benefit. If, say, Jennifer married Raphael more quickly than she might have considered doing because he needed to get status, that's okay, because that's just one of the reasons they got married. And often what I'll suggest is that you remember, especially if you go back to your ancestors, that people haven't always, love has not always been the main reason people get married. And that's often true for people coming from other countries. It may be, you know, an economic agreement, essentially a contract between families. So keep that in mind when someone's asking you to think about whether this is a good faith marriage. This is an empty slide. Here we go. So here's a question. Can you make findings or require information on battery extreme cruelty? And before we get into that, let me ask you, what kinds of domestic violence do you think you encounter in your courtrooms, or those of you who represent people in court, that aren't physical battery and that may not even qualify as a crime? Maybe while we wait for people to answer, you can jump in.
For me, the one that comes to mind mostly is the economic controls. You know, the not being able to work and the taking of the economic self-sufficiency of the individual. Eva says verbal abuse. Yeah, it doesn't rise to the level of what our statutes say.
Right. Right, and we often use a power and control wheel, both the one that's the general one and then one that's designed for immigrant survivors, because in addition to what you two have suggested, this degradation, I guess this is typical, is it giving them money and making them come back with the receipts and then taking the money away from them. Isolation is a huge one with immigrant survivors, and often that's combined with the disinformation. It's like, if you go talk to anybody, you're going to be deported kind of thing. So the control over their ability to work is another example that's very true with survivors. So essentially, any form of power. Go ahead. Yeah,
I was going to say, Eva's comment on privacy abuse, this is really a really big one, basically using the internet to monitor people's lives and impose all sorts of restrictions on their ability to have anything private, including where they go.
Wow. That's actually really interesting and fairly new. So, you know what would be really helpful is to get some materials on that and share that with the folks who make these decisions. We actually, over the years, have kind of co-trained each other on how to handle these cases. This is a fairly new one.
Yeah, FCJ has several programs and several presenters that can give you information on that specifically.
Great. That would be great. Because the beauty of this is that as long as you basically show it's a form of power control, essentially anything can count. Because as we know, abusers can be very idiosyncratic in the way they use power and control, and in very bizarre ways. And in fact, in some ways, that's helpful for a case because every case is different. And you know, they're trying to tease out the cases that look like someone just read a website on what domestic violence is from the people who have actual cases. And this is why we suggest it's helpful if you all feel comfortable making findings about extreme cruelty, if it's not obvious. What do you think about that, Judge?
Yeah, I think anything we can use to talk about what is the definition of extreme cruelty at this point without actually having to have a physical touching, because most of our statutes are all about the physical touching, would be helpful. I think we have some laws around the country that are starting to change, so they're recognizing that power and control can be much more than just a physical act of abuse, but we have a long ways to go. And I'm all about pushing that envelope, Gail.
Great. So for those of you who aren't the judges, one thing I recommend to the advocates and attorneys who appear in courtrooms is that you start asking your judges to make these findings. Even if the first time they say no, if you put it in the context that this is a pattern of power and control, perhaps they would be willing to actually make some findings in the record. And that's very good evidence for the immigration system, because you guys are seeing the person, whereas they're just reading the papers.
Right, and it's important for the judge to be discussed with the judge as a fact. It's simply a finding of fact that they're making. Someone else can make the conclusions, but if you don't have the finding of fact, that's an issue that you can't correct later.
And you know, that's a really good point, because in fact it would be more useful if you made a finding that she told me he did this and that, and I believe her and it's credible, rather than characterizing it as humiliation.
Exactly.
Right. Excellent. Okay, so I just asked this. So the other eligibility requirement that we find is very hard for VAWA self-petitioners in particular is the documentation of residence with the abuser, and that the abuser is a U.S. citizen or lawful permanent resident, because the abuser controls all the documents, or he or she won't share that information. Do you have any thoughts, Your Honor, on if I asked you to either make the abuser or the alleged abuser provide evidence of his status because it's part of the pattern of power and control? Would you be comfortable doing that, or is there some other way you can help with this?
Oh, you mean make the abuser? I misunderstood your question.
Well, so here's the problem. It's like I show up in your courtroom and I say, Your Honor, this woman's trying to get a self-petition. This guy over here is refusing to give the evidence that they live together. He's got all the documents, which she needs to be able to get status, and he's refusing to tell us to confirm that he's a U.S. citizen or lawful permanent resident. This is his control of the immigration system is part of the pattern of power and control that we think you can sanction. Is there anything you can do? Could you ask him to provide his green card or his naturalization? Could you make a finding on the record? Could you make him cough up the documents that show they live together?
Yeah, I think depending on the kind of proceeding that you have, if I have a family court proceeding, I can make him produce the documents. If I have a protective order, I can use the catch-all provision in the end to have him produce the documents and to enforce it with a contempt power. Absolutely. I mean, if it wouldn't be any different than, say, you need a work permit and you can't work without the work permit, I got to figure out a way to get that work permit to you, or asking somebody to present their tax returns because they're subject to the order of the court. So I think sometimes we get hung up into whether the law specifically delineates a particular action rather than using the catch-all provisions to try and basically get to what justice is. So yeah, I would use that.
And it sounds like in the context of custody or divorce, you'd be probably doing discovery anyway, or hopefully people are asking for discovery anyway. So some of this might come up soon.
And hopefully, if you're talking about lawyers understand that these issues are not different than anything else. So all of those evidentiary rules apply, and all the rules of discovery and evidence apply. So sometimes I get a little frustrated with lawyers who come in and just say, well, I don't know how to get that. And there is a legal procedure for getting that, and they just don't think to use it in these kinds of arenas. They would not even think twice about using it in a medical malpractice case, but they get a little gun-shy of trying to do it this way.
So there's a little practice pointer for you lawyers and advocates. Spread the word. The third thing, good faith marriage, is actually the main reason we're seeing these cases be denied, and often it's because it's really hard for the survivor to get the evidence of it being a bona fide marriage, and she has to rely solely on her own declaration. So I'm wondering if a couple is presenting themselves in court for one of these reasons, and the lawyer asks you whether you could make some findings on whether you think it's a bona fide marriage or a real marriage that's not, engaged in solely to get immigration status, would you be comfortable with doing that and providing some facts that support that?
Well, again, you're looking at facts, and if you're not talking about making a conclusion in the end, you certainly can put the facts on the record and make a determination of whether or not somebody is credible. That's what judges do every day.
Yeah, and that's extremely helpful evidence, because it's what the immigration system would call primary evidence, because it comes from another system to which they should give deference.
And I think in the issue of credibility, though, Gail, that's how I would frame it with judges, that this would all support her credibility or his credibility based upon the facts.
Oh, that's a great idea. So frame the request as an effort to prove her credibility in what she's alleging. I like
Correct.
that. Okay, and I think we kind of covered this. You mentioned the catch-all provision, but we are suggesting to the judges on this and to the advocates and attorneys to really use that kind of catch-all provision in your protection orders to capture some of this if it's needed in survivor cases. We've seen judges put in the catch-all provision that the abuser shall turn over certain documents that were brought up as we discussed, or that they shall turn over a copy of their birth certificate or their green card. Do you have any other thoughts on things you could require in this catch-all provision, Your Honor?
Well, I think sometimes it's the payment of fees as well, because it doesn't do you much good if you can't pay for the translation fees and the rest of it. But any economic assistance, I always try and figure out a way to get it in there as well.
Great.
And all of that is again, enforceable by contempt. So that's a really important tool in the toolbox for judges. But again, you know, sometimes when you get a large calendar and you're moving things along, you need the advocate or the attorney to bring that to make the request. You can't expect the judges will just do this from the top of their heads. You're going to have to make that request. And
right.
And it may be hard for the judge to do it the first time, but after the first time, then you'll see that it's a lot easier for a judge to go to that same place when you come back with the next client.
So Eva's asking, if a domestic violence victim did not file any police report, but the judge determined there was enough for an order, will they sign a U visa certification? Well, that's an excellent segue into the next section. But before we do that, let me just say, Eva, that if it's a self-petition, you don't need a police report, because the idea is that but for the abuser's control of the family-based process, this person should have gotten status. But as you say, that's not going to be true for everybody. So that's where we got to the 2000 U visa. And Congress said that it has a dual purpose. It's to strengthen the ability of law enforcement to investigate and prosecute crimes. And they view it as a tool for them to do that, especially with communities that are afraid to talk to them, like the undocumented community. And it also provides a form of humanitarian relief to the crime victims and their family members. So what Eva's talking about is this long list. So you can see there's a lot of things here, but as I mentioned, it's mainly the domestic violence and the sexual assault categories that people are filing under. And there's some felonious assaults, I would say, is the third biggest category. So let me ask you, Eva, and the judges, I mean, one of our arguments is that these are categories of crimes, and the government has agreed that they consider them categories, and the most obvious example is domestic violence. There could be many kinds of crimes that are domestic violence but aren't called that. Like, what have you encountered, Your Honor, that could be a domestic violence crime, depending on the facts, or just isn't called domestic violence?
Well, almost anything here qualifies. The one I like is the blackmail and extortion. Because those you're thinking, well, what do you mean? Aren't they family? Well, yeah, but those can be really very felonious.
Interesting. Yeah, I was thinking more of like, you know, misdemeanor assaults are not felonious assaults, but they may be domestic violence crimes, right, depending on who the players are. And when I do training for law enforcement, they always come up with all these great ways that they could charge, you know, great things they charge people for domestic violence, like terroristic acts and things I'd never even heard of, which aren't called domestic violence, but depending on the facts, they may be domestic violence crimes.
I think anytime you have a victim who is under some power and control, and then you have a crime, you have to start looking behind what the facts are to see what the motivation is in order to get to that delineation.
Mm-hmm.
You know, because for me, whenever I have one that is like a forgery or a misdemeanor theft, I start thinking about what is the motivation for the forgery or the misdemeanor theft, and usually there's somebody behind them forcing them to do something they don't really want to do.
That's interesting. So that's the blackmail extortion again also.
Correct. Mm-hmm.
The other thing to be aware of for the judges in particular, because we have seen AUSAs mostly use this, is obstruction of justice and witness tampering. So yeah. Someone may be a victim of a crime that's not listed here, but then like they're reporting, this actually comes up with a lot of workplace crimes, they're reporting their employer to an employment like the DOL or EOC, and then the employer starts threatening them. Or they're a victim of notario fraud and they've reported it to the state attorney general, and the notario starts to threaten them. So that then becomes witness tampering or obstruction of justice. So it's interesting because this, I would say, is the one way that kind of witnesses kind of get into this little loophole, because they actually become victims of the crimes of obstruction of justice or witness tampering. Something to keep in mind if you do criminal cases. Okay, so the requirements for the U visa are, it's funny, I don't do all these fancy things. You need a certification. So this is, you cannot get a U visa without a certification from someone who has expertise on the investigation, prosecution, or detection of crimes. From the vast majority of U visa applicants, that's going to be police or district attorneys. And as I mentioned, for workplace crimes, it's often the EOC or DOL. For judges, the phrase that applies to you is that you detect a crime, because CIS, the judge is in the law, the word judge is in the law. So they were trying to figure out how to interpret it. And the way they interpret it is that in the course of your work, you detect a crime, and it's your job to detect the crime. So the challenge here, Eva, is whether in a civil proceeding, a judge feels comfortable saying they detected a crime. What do you think, Your Honor?
I think it depends on the facts, right? But the way the statutes work, if I can detect a crime, but it isn't my job necessarily to report the crime, and if the individual has chosen not to, they may have their own reasons. So it's a hard one to convince many judges of, but we're working hard to get them to understand that it is possible. And in fact, you do not need a police report to be able to give this certification.
And then even if you're not comfortable doing that, if, say, they're there in the context of a protection order, could you make findings about the harm, which the substantial physical or mental abuse is a legal term of art, but it's essentially psychological or physical harm that flows from the crime.
And I would feel comfortable making those factual findings. And again, this is one of those for judicial leadership and education and training, because if the advocates or the lawyers representing people are able to present the evidence, then the judge can make the findings. But you can't just create them out of nothing. So the facts have to be presented. And many times people are hesitant to present a lot of these kinds of facts. But if it's presented in a way so that you can telegraph to the judge what it is that you're trying to get accomplished here, it may be helpful, not in that particular case in front of that judge in that particular hearing, but in educational opportunities outside the courtroom. It's really important to try and get that across. Whether it's
so if those of you who are lawyers or advocates, I strongly encourage you to contact us as ASISTA later, because we'd love to both have your input and share with you materials we have to get the word out in your communities, because as the judge says, there's only so much the judges can do in their courtrooms, especially in terms of educating people about what their options are, because you want to avoid the appearance of bias, I believe, which is an issue also on the certification signing, I would imagine.
Well, and then you don't want the judge to be taking off and saying things and doing things that are harmful for your client just because the judge is thinking they're being helpful, right? That happens.
Okay, that's good to know.
Oh, the judge says, oh, I'm going to do this because I think this is going to be helpful, and you just cringe because you're like, no, that's not what we wanted you to do, Judge. But, you know, a little bit of knowledge is a real dangerous thing, so it's really important to educate.
And then one issue that always comes up when we do the trainings is, at what point would you be willing to sign a certification? I think the general rule is not while a case is going on, because you want to avoid the appearance of bias. But say a protection order has already been issued and nothing else is happening. At that point, could a lawyer come to you and say, would you be willing to certify domestic violence based on this?
Yeah, yes, I think so. Not when the case is pending, however. That would be problematic.
Right. So you know, I mean, every judge feels differently about this. So Judge Ramona has been doing this a while, and that's why she sounds so comfortable doing it. We would like to encourage you, those of you who have never even thought of us, to start thinking about it. And certainly, I think you're willing to talk to judges about this if they have questions for you. Your Honor?
Yeah,
At
yeah.
federal?
And,
okay.
and I'm currently working with a grant from the Kellogg Foundation to educate judges in this arena. So we have some bench cards and some materials, and FCJ has some materials. So if someone is feeling this judge is nuts today, I don't think I can do any of that, just reach out to us, and we'll let you have the same information. In the end, you've got to make the decisions that are comfortable for you, but it's really important that you have all of the resources available to you so that you can come to an informed decision, and not just say, well, I'm not going to do that, because we have a responsibility to provide access to justice to individuals, and having that, using whatever tool is in our toolbox to get that accomplished, I think is in the best interest of all of us.
Thank you. So the final issue that we wanted to just flag for you that we've seen coming up a lot in both the civil and criminal court systems is a person being charged with either a crime or domestic violence raising as a defense that the person making the allegation is just making it all up in order to get a U visa. And there are certainly Brady issues involved, and in your materials you'll have the link to a webinar I did for the Family Justice Center Alliance with Wanda Lucibello, who was a district attorney at the time, and Susan Briel, who's one of the judges who trains with you. And it was a very interesting conversation about how to deal with that, because you want to juggle the due process rights of the accused with the credibility and the perhaps attempts at intimidation of the survivors. So it's a challenge. And I did want to also flag for you the other things in your materials are the links to those two studies with more detail, and an article I wrote for the NCJ, FCJ many years ago now on kind of red flags for judges, things you may encounter in court with immigrants, and just things to keep in mind.
Yeah, and
do you have any thoughts on that?
Yeah, the only thing that I would add to that is it's really easy for perpetrators to send what we would call red herrings into the process. But I think if you can focus the judge on what's credible and that you limit things to what the facts are, I think you can get beyond that.
Right, and this is when I talk to the judges about it, and I think you say the same thing, Your Honor, is that it's always about the facts. Right, so don't let the fact that this is about an immigration case change the focus on the facts.
Exactly, and it has to be the facts, and we have to use all of our resources to figure out who's telling us the truth and who's lying, and that's a job, again, that judges do every single day. It shouldn't be any different because in this particular case somebody is raising this issue of what they would normally be bias or self-interest. Immigration is not the only bias or self-interest that individuals accuse themselves of, but judges still make those decisions on an everyday basis of who's telling the truth and who's not.
And my one practice pointer for the lawyers and the advocates in the audience is I think there are ways that you can turn the table on the perpetrators. I think lawyers tend to have a knee-jerk, resist subpoenas, resist sharing. I think there are ways that you can say, well, we're happy to give you all the hearsay evidence in the U visa application. You really want that on the record? And you'll hear more about that in the webinar that we did with Judge Briel. So I think this is an area where the advocates and lawyers can be creative, and the judges, as you say, need to focus on the facts and what's going on there in the courtroom, really. Is someone intimidating another person? Are there real credibility issues? So let's do a little bit on human trafficking, because another hot topic. The two big kinds of trafficking are trafficking for commercial sex and trafficking for labor. That's what these two are in legalese. And the red flags for you all, I think, if you see people in your courtroom where you have any of these questions, again, I don't know if you can do anything as a judge, but this is where having victim witness advocates and materials that they can give people who might be survivors of human trafficking might be helpful. Your Honor, do you think you've seen victims of human trafficking who may not even self-identify that way, and in what situation?
Oh, I think I see them all the time, and unfortunately I've seen them for the 23 years I've been on the bench, and I just haven't recognized them because they're basically in plain sight. Some of my juveniles who run away and then come back, and suddenly there's a history of things that I have no idea what happened, but they're not willing to talk to me about those things. I have individuals who get picked up for little petty crimes, little misdemeanor thefts, or I think I had one last year where it was a forgery where they had stolen checks, and the only person that was writing the checks was this particular young woman. And by the time that all came to pass, everybody else had sort of disappeared, leaving her holding the bag. I think they're everywhere, we just don't see them because we're not looking.
Do you have other suggestions about what you can do as a judge about that?
Well, it's really hard to get anybody, of course, to share with you from the bench, but we've really done put our efforts in getting our community resources in place to get advocates in the community that are able to provide information. So we have some brochures in the jail for booking. We have some brochures here at the courthouse. We have our domestic violence shelters are working with our local trafficking task force that's really been championed by our Sisters of Perpetual Adoration, which is a Catholic institution here in town, to see that we can provide safe places, because you can't just say, oh, you're the victim of trafficking without giving them an option. So it's been quite a challenge, but people are hiding in plain sight. We just need to open our eyes and see it. When you have young people who are being arrested and then they're being bonded out quickly, but they're not meeting your gaze when you ask them who the person is. They just say it's my uncle. We would take that for granted before. I don't take it for granted very much anymore. I ask more questions.
That's great. I don't know if there are any findings you can make that would help on human trafficking, because often, frankly, they're represented by the trafficker's attorney, which is another kind of red flag. The same guy seems to be representing a lot of young women, you know. And I think that, I mean, the other place to keep your eyes open for this is obviously prostitution charges, because that's so many women are brought in and used in like nail salons and massage parlors, and they're really being used as prostitutes for forced labor. And this is much harder for them to leave even than domestic violence, because it's so much both physical control and so much psychological brainwashing that it's very hard for them to even figure out how to live a life outside of the human trafficking situation, which is
right. And I think that's why they don't, you say, well, how come they don't run, Judge? I'm like, well, you can't expect people to think there's an alternative if that's the way their whole world is structured. So basically, right?
And they may have been sold into slavery by their family. I mean, they may have been experiencing this since they were children, so they don't know any other way of life. So it's a really difficult problem, and we would encourage you all to keep your eyes out for it and even get involved in your local trafficking task forces if this interests you. Okay, so we've discussed some possible roles for judges. Do you want to share some of these and any others that you think might be helpful, Your Honor?
Well, I think we put these on the slides because they're the main ones. But what I wanted to say in this part of the training is, if you're a judge, recognize that immigration status can be a weapon, and recognize when it's being used, especially whether it is the status itself or the lack of the status. And it can happen when you don't even realize it. There are two individuals in a car, and one is the one that's driving, and the person who's driving doesn't have any status, and the other individual doesn't have any status either. But who's going to get the ticket and who's going to have the record? It will most likely be the victim of domestic violence in that car. I've seen that occur. And providing, for me, information is power. And from the bench, I can't give people the kind of information that they need. But I certainly can encourage my community to step up to the plate and provide the kind of information in the immigrant community to offset the misinformation that a lot of people are getting from their abusers and from their traffickers. We also need not just to train the judges and the advocates, but also our court staff. Every time there's an opportunity, a human contact, there's an opportunity for change and an opportunity to make a difference. And if the people at the front of my courthouse are not welcoming to the people who are coming to the courthouse, that's a really big problem. because access to justice doesn't just start in the courtroom. It's everything that has gotten that person to that place. And I think it's our responsibility as judges to understand that and to lead that.
Thank you. That's terrific. So we will put up our resources and entertain questions. And really encourage you to come to the full-day training. I think it's a lot of fun, and it tends to be a small group. So, for those of you who are judges. For those of you who aren't judges, send me an email, and I'll get you hooked into ASISTA, because we have all this free stuff on our website and do trainings and all sorts of things, technical assistance.
And those of you who are judges, I would encourage you to look at the National Council of Juvenile and Family Court Judges as an organization to join, to be part of this process. We are under attack. The judicial system is under attack, and we really have to preserve the importance of that third branch of government. And it's really easy to just be overwhelmed by what we do every day. But we are part of the big process, the big access to justice machine, and it's important for all of us to stand together, because you can't do this by yourself. And quite frankly, after 23 years, right, Gail, some of us begin to burn out. So we're looking for other changes in our place.
New blood.
We need new blood. That's right. We need new blood. But thank you very much for giving us your time today. I'm not seeing any questions.
No, we appreciate you all being on the webinar, however. Patricia, should we just end early? Or
Yeah,
Jennifer, do you want to have anything you want to share about the EJC and the CJS in probably Austin in October, right?
Yeah, I'd say go to the NJIDV as a partnership between us and Futures Without Violence, and so that particular website has all of the training that's available for judges. You also can go to the council's website, the National Council of Juvenile and Family Court Judges, for many resources that Gail referenced during the webinar, so feel free to reach out to us as well.
Okay, well, thank you all very much. Really appreciated everyone's participation.
Thank you, everyone.
Bye.